Good morning, and welcome to the SJSU Plan Giving Virtual Seminar Series. My name is Nick Messing, and I'm the Alumni Engagement Specialist at San Jose State. The seminar series continues today with our webinar, Introduction to Special Needs Planning, brought to you by the Office of Plan Giving in partnership with the SJSU Alumni Association and Special Events. We want to thank our presenter, Ellen Cookman, Principal of Cookman Law in Palo Alto, for graciously agreeing to share her time and knowledge with us today. We will start off with some brief housekeeping items, followed by the presentation, and we'll conclude with a Q&A session. Throughout the webinar and following Ellen's presentation, we will have a brief Q&A session. Please submit questions using the Q&A button on your toolbar at any time during the presentation. There may not be time to answer every question during the Q&A, but we will download the chat and follow up with any unanswered questions in the next few days. Please be aware that we are recording today's event and it will be available to view on our website in the near future. Ellen Cookman is the principal of Cookman Law in Palo Alto, California. She is passionate about helping families of all shapes and sizes plan for the future and utilize available resources. Ellen is a certified specialist in estate planning, trust, and probate law from the California State Bar Board of Legal Specialization. She received her JD from UC Berkeley School of Law and received her LLM in estate planning, trust, and probate from Golden Gate University. Ellen lives in East Palo Alto with her husband, who's also the bookkeeper at Cookman Law, two cute and very active boys, and a boxer pit bull mix named Ulysses. This and our other seminars support SJSU's mission as a center of knowledge, including estate planning and financial literacy. Without further ado, please welcome Ellen Cookman.
Great, thank you so much. I appreciate that. And I love sharing about special needs planning, so I'm really glad to do that today. So let's go to the next slide. I actually don't have control over the slide, so that always makes it a little bit exciting. I'd like to share, I know those are some credentials, but I wanted to share how I actually got into this field. So I was at a big firm for a few years and I completely burned out. I did litigation, and if you've ever dealt with a lawsuit, it's awful. And so I'm a lawyer who doesn't like lawsuits, which is kind of funny. So I went to teach for a year at a small school called Hope Technology School that does full inclusion of typical and special needs kids. And while I was there, I attended a parent support group, kind of like this presentation, about special needs planning. And it really piqued my interest because I thought, wow, I can actually help people in the community and listen to, who they love and what they have, and really set them up great for the future. So that was 13 years ago, and I've been in this field ever since. And I've had my own practice now for 5.5 years. I'm in Palo Alto. So I love this, and I really hope that you get a lot out of it. I come from a family of lawyers and teachers, so I love the back and forth of answering questions. Sometimes it feels a little bit harder on this Zoom platform, but I'd be really happy to take your questions. So let's go on to the next slide. Okay, so what are our goals when we're doing estate planning? And what is estate planning? Because I really want to do like kind of the basics. Why do we do this? So our big question is what happens upon your incapacity if you can't manage things yourself, or upon your death? Because one of those things is going to happen to all of us, right? And I know a lot of parents who stay awake at night worrying, how is my child going to be taken care of, especially when they have special needs? No parent or no other person will be as good as the parent in advocating for their child, typically. So, so these are our planning goals when we're looking towards the future to set up the child for success. We want to maximize that child's quality of life. We want to protect them from financial predators. A lot of times people who don't have full capacity can be easily swayed to get that credit card or buy a round the world cruise that they'll never use. So protect them. At the same time, we want to maximize their independence. I think every parent wants their child to live up to their full potential. So we really want to maximize that. And then children who are disabled, and we're going to talk about this next, qualify for certain public benefits. And so we want to maximize those. and we're really setting up a financial surrogate parent for that child. So that's another goal. And it's funny because we're in law, but again, I don't like lawsuits and I don't like the court system. So our goal is really to avoid the court system. And a lot of the planning that we do is done outside the court, which makes it more efficient and effective and less costly. So we like all of those things. Okay, let's go to the next slide. All right, so I promised I'd talk a little bit about public benefits. So here's the issue. When a child turns age 18, all of a sudden they become an adult, which is really funny if you know a lot of 18-year-olds nowadays. My boys are ages 8 and 6, and my guess is when they turn 18, they're not going to be completely self-sufficient. But you know, we do what we can. Under the law, they become 18. Now, why is that important? Well, what's important is that once a child becomes 18 and they're an adult, the parent's money is not attributable to them. So all of a sudden a child is poor, right? They don't have any money. So at that point, they can qualify for these 2 benefits that are listed at the top of the screen. They can qualify for an income stream called SSI, or Supplemental Security Income, and then also a health insurance program called Medi-Cal. Those are the 2 things that when you're disabled and you can't work and support yourself, those are the 2 things that you don't have. You don't have an income stream coming from work, and you don't have health insurance. Now, my hope is someday we'll all have a great health insurance program, but we're not there yet. So, so if you're disabled and you can't work because of your disability, or you can only work just a little bit, and you have under $2,000 of countable assets, typically that's everything but you know, you can own a residence, and that's not countable. You can own a car, but anything like in a checking account or mutual funds, those are countable. And if you have more than $2,000, you don't qualify for SSI or Medi-Cal. There's a couple of other income streams that are not based on how much you have in the bank. One of them is Social Security Disability Insurance, and then the other one is Medicare. Okay, so so those, it doesn't matter if a child receives an inheritance directly, but with SSI and Medi-Cal, it really does matter. And I put a kind of how you qualify for the health insurance. If you get even $1 of SSI, you automatically qualify for Medi-Cal. And after you've been on Social Security Disability Insurance or child disability benefits, that's when a parent retires or dies and their disabled child gets part of the income stream that the parent got, while the parent, while they're alive, continues to receive the full amount. After 2 years of receiving that type of benefit, you get Medicare. Okay, so our big concern are the top 2. Although the bottom 2, we also use special needs trust quite a bit. So what does that mean? So remember I said you have to have under $2,000 of countable assets. So what happens if a child receives an inheritance of $500,000? All of a sudden they have more than $2,000 of countable assets, and they're bumped off these very important public benefits programs. So here's what we do. Let's go to the next slide. Here's the solution. The solution is a special needs trust. Okay, what is a special needs trust? First of all, let's just talk about what a trust is. A trust is an agreement between the person setting it up and the person managing it for the benefit of the beneficiary. And there's a lot of trusts out there. You guys might have a revocable trust. There might be some irrevocable trusts for different purposes. So this is a certain kind of trust that needs to be irrevocable when money goes in. Because here's how it works. It holds money for a disabled person, and it doesn't interfere with their public benefits. Now, why doesn't it interfere? Because somebody else is acting as trustee of this trust, and the child doesn't have the ability to demand money out of that trust. They can't reach in and take out the money. They can't threaten to fire the trustee. And since everything is up to the trustee about distributing assets, and the child has no say in the matter, the money does not count as the child's money for public benefits purposes. So it's really nice. You can have your cake and eat it too. You can have, the child can have their SSI and Medi-Cal benefits and SSDI and Medicare. Sometimes people have Medi-Cal and Medicare. We call them Medi-Medi. You can have all of these benefits and $1 million in a special needs trust, and that doesn't count towards that $2,000 limit of several of the benefits. So it's like a safety net. The idea is that the government provides the benefits that they do, and anything that's needed in addition, which a lot of things are needed, are provided by the Special Needs Trust. Okay, let's go to the next slide. All right, there's two different types of special needs trust that you should be aware of. One is called a third-party special needs trust, and one is called a first-party special needs trust. So the third-party special needs trust is the type that most people set up. That is when the parents have in their estate plan, they say, okay, when I die, everything goes equally to my kids, but Johnny's portion, my disabled child's portion, goes to a special needs trust. So the parents are the third party. They're the people putting the money into the trust. Okay, the first party special needs trust is different in that that is the disabled person receives money outright. Maybe there is a litigation settlement and the disabled person gets money, or maybe they worked for a while and then they became disabled, and so it's their own money. They can put this money that they have already into a first party special needs trust. So I want to talk about the differences between these two different types of special needs trusts. Let's go to the next slide. Okay, so here's a chart that we talk about. So the third party special needs trust receives all of the money from anybody else, okay? Anyone except the beneficiary themselves. So you can set up this third party special needs trust and grandma can put money in, parents can put money in, uncle can put money in, a sibling can put money in, but the disabled person cannot. As opposed to the first party special needs trust where the disabled person is the only one who can put money in, okay? Now the first party special needs trust is a bit limited because you have to put money in before the disabled person is age 65. If the disabled person receives money after age 65, you can put it into a pooled trust, which is basically typically run by nonprofit organizations, and they pool together a lot of smaller special needs trusts. And a disabled person with over age 65, they can put their money into a pooled trust. Okay, other restrictions on first party special needs trusts. They can only be established by a few people. The beneficiary, and that's kind of recent, beneficiary can, if they have capacity, they can set up their own first party special needs trust, and so can a parent or a grandparent. Otherwise, you really have to go to court to set up the first party special needs trust. And then the big drawback of a first party special needs trust is upon the beneficiary's death, Medi-Cal wants their money back, and they'll bring a reimbursement claim for money paid on behalf of the beneficiary, and that money has to go back to Medi-Cal, and then any remaining money goes to the beneficiaries named in the trust. Whereas the third party special needs trust that somebody else set up and funded, upon the beneficiary's death, Medi-Cal does not get any money back. So the third party special needs trust is more beneficial in this way. All right, let's go to the next slide. So I think the biggest choice that parents need to make is who's going to be the successor trustee of their child's special needs trust. And this is such a big choice because this is really who's going to do everything that the parent usually does, right? So you look at your different options, and sometimes I can have like an hour-long conversation with clients about this choice. So this is a very brief summary, right? So first of all, they'll look around and see, okay, are there any family members or close friends that we trust for this role? Now, when we're talking about trustee of a special needs trust, there's a lot of rules that the trustee needs to know. And also this is a long-term project because this child might be only age 12 when the trust is funded. They might have 70 more years to live. So, you know, the trustee, that's a big ask of somebody. And I often recommend that they can name other professionals. So there's private professional fiduciaries. Those are people who have been licensed by the state of California to manage trusts. So I think they do a very good job, and they can be a very good choice. Now the main problem is that usually private fiduciaries are my age or older. And so for a 12-year-old, they won't be around all of the 12-year-old's life. So you need to look to see what is their succession plan, all right? But private fiduciaries typically charge a little bit less than a bank or a trust company. So those are the other options. Now, the bank typically charges a percentage of the fees, but a lot of that is taking into consideration that they're also managing the assets. So that includes the 1% fee that financial advisors usually charge. So, and the main benefit of a bank is the longevity. They'll be around. And if they give up their trust department, then somebody else will take it over. So you know, you look at what's needed. We should really think about, should we name a family member, a sibling, as trustee of the sibling special needs trust? Because a lot of people say that, oh, you know, well, Betsy will be around for all of Johnny's lifetime. Let's name Betsy. But one big challenge is that can cause a lot of friction between the siblings, because now Johnny feels like his sister is the gatekeeper for the money, and the sister just wants to be a support, right? So there's another option in that situation. So let's go on to the next slide. All right. So one option in that situation where we have Johnny, the disabled person beneficiary, and Betsy, the sister, is we can name Betsy as the trust protector. So she has kind of the oversight role where she gets yearly accountings. She has access to the books, and she can also remove and replace the then acting trustee if the trustee isn't doing a good job. Because a big worry is, you know, when parents put this in place, when they're gone, who's going to look after their child's interests? So if they have another loved family member and trusted family member or friend nearby who can check in on the beneficiary and also oversee things, but it's not as heavy of a lift as acting as trustee. Then you can also name co-trustees. You can say that an individual is to act as co-trustee with a bank, for example. Advisory committees used to be pretty popular, where you'd name the beneficiaries, psychiatrist and case manager and some family members, but that tends to get pretty expensive if the special needs trust is paying for all of them to meet together maybe once a year or twice a year to advise the trustee. So I don't see that coming up as much. But those are your main options for providing oversight to the special needs trust, and the trust protector option has become much more popular. All right, let's go to the next slide. All right, so now one thing that I always encourage my clients with disabled kids to write is something called a memo of intent. And this is basically a letter from the parent to the successor trustee that says, you know, dear successor trustee, here is everything that I want you to know about Johnny. And then they just kind of download all the information that they know, gained over years of experience of dealing with Johnny, his talk about his meds, his allergies, what makes him really happy, what makes him really mad, any family members or friends that live nearby that you want to continue interacting with him. If you have ideas about his housing for the future, housing is a big issue, especially in the Bay Area, but anywhere. So those are certain things that you put in this memo of intent. It doesn't go in the special needs trust. And the nice thing about that is that the parent can update it occasionally, and you really don't need to circle back to the attorney and worry about attorney fees, but you can keep that updated. I usually ask for a copy, although it's not always provided. So I'd like to pause for a minute and see if anyone has any questions. We've covered a lot of information, and I'm going to go on to another topic, but I do want to see if there's any questions about special needs trusts.
Yeah, so far our first question is it beneficial to set up a special needs trust even though the child does not qualify for public benefits?
So that's a wonderful question. So as we were looking at that chart with you know, SSI, Medi-Cal, SSDI, Medicare, with SSDI and Medicare, for example, those are public benefits, but receiving an inheritance does not disqualify the child from that. So I always suggest, or always is a strong word, but I often suggest setting up a special needs trust anyways for the management purposes, because now you're making sure that somebody else is managing the assets for the child. And if they ever do qualify for public benefits in the future, a lot of times people apply and they're denied the first time around or even the second time around. And then finally, they're accepted. So you don't have to be disabled to be the beneficiary of a special needs trust. I think it's a good idea to set up a special needs trust. And also the thing I want to mention is that a special needs trust is very flexible with the distributions that it can make. So it can distribute for just about anything. It's not supposed to distribute cash to the child, although you can get something called a TrueLink card, which is basically a debit card that the child, if they have more capacity and can do this, they can use that debit card to buy things. And the debit card can be programmed to be able to buy certain things and not buy, cigarettes or other things that you don't want the disabled child to buy. I think it's a very good management tool, even if the child doesn't necessarily qualify for public benefits, which can definitely happen, especially in the mental health community. Unfortunately, that's not a disability that people see right away, and sometimes it can take years to qualify for public benefits.
Great. Our next question we have is, how is special needs defined? If child has IEP, neuropsych, does this suffice? ADHD, dyslexia, yeah.
Right. So that's such a good question. So disability, so we looked to the Social Security Administration to see what do they want to see. And the type of disability really isn't the key here. What's key is that they have a disability that affects their ability to work and support themselves. Okay, so for example, Stephen Hawking was quite disabled, but he still was able to work and support himself. He would not be considered disabled by Social Security Administration because he was still able to work despite his disability. But if because of your disability, you can't work and support yourself, that's when it's actually considered disabled. Whether that's caused by being on the autism spectrum, ADHD, mental health challenges, whatever it might be, if you can show that, and having an IEP is helpful to show this, having, other documentation is very helpful. You usually bombard them with documentation, but that's usually how they test whether or not the person can work. So if they've been able to work for 3 months, and then they don't work and they apply, a lot of times they'll be denied because they'll say, well, you were able to work for 3 months. What happened? So it can get a little bit tricky being in that gray zone.
All right, that is all the questions we have for right now. And again, to all participants, feel free to keep submitting the questions throughout the seminar. And actually, I think one more popped up. So we have one more question right now. With a child who receives public benefits, for example, Medi-Cal or IHSS, can the child receive smaller cash gifts in the form of checks from family and friends? And can the checks go into a parent bank account and not be counted as income for the child?
So I have a wonderful answer for that, and it's actually the segue to our next subject. So let's go to the next slide, and I'm going to answer that question. Okay, so next slide, please. I love it when there's a nice segue. Okay, let's talk about the ABLE account. So to answer that question, the answer is set up an ABLE account for the child to receive small checks. So let's talk about the ABLE account. What is it? Well, I want to give you the background first of all. So this was actually passed in 2014. So that's pretty recent in terms of estate planning. There was a group of parents in, I believe it was Virginia. They were parents of adult children with Down syndrome who were working part-time, but they couldn't save up their money because they had to spend it down below $2,000 every month. Well, what a pain. Like, what if you want to buy a car or a modified car or a fancy TV or whatever you want to buy? It seemed like this is not, the American way that you have to spend down money. So there was, they spoke with their congressperson, and there was great bipartisanship working together to pass the ABLE Act. So it stands for Achieving a Better Life Experience. And basically this is a checking account for a disabled child that doesn't interfere with public benefits. It's modeled after the 529 plan. In fact, it's called a 529A plan. So the idea is that post-tax money goes into the ABLE account, and the account can grow and grow and grow. And if the money is distributed for what we call qualified disability expenses, which I'll talk about in a second, then you don't have to pay any capital gains tax on it. So yeah, so those are the things that I just mentioned. And then also, Medi-Cal does not get their money back. So I'll talk about that in a second. So let's go to the next slide. All right, so to be eligible for an ABLE account, the beneficiary has to have a qualifying disability. And unfortunately, that disability must have manifested before age 26. Okay, I say unfortunately because that disqualifies some of some people who have mental health challenges that may manifest at age 30 or even 40, or maybe somebody became disabled, was in a car accident and became disabled later on. And they're trying to extend that to disabled before age 46, but they just haven't passed that yet. The child can only receive one ABLE account, or they can only set up one ABLE account. So you can't set up one in California and one in Ohio and one in Tennessee, you just get one. The main limitation, and I think it's on the next slide, is that you can only put in $15,000 per year into the ABLE account. So that doesn't mean that grandma can put in $15,000 a year and somebody else can put in $15,000. It means that the account can only receive up to $15,000 and then it's capped off. Then it doesn't get any more. All right. So an ABLE account is not intended to replace a special needs trust. Instead, it's supposed to supplement it and work exactly like the person who asked that question, which is why I was so excited about that question. It really is to receive smaller gifts. And it's also for a disabled person who's working part-time, they can save their money by putting it in their ABLE account. Let's go to the next slide. Okay, so I mentioned contributions of up to $15,000 a year. Now that number is linked to the annual exclusion, which is the amount that somebody can give to as many people as they want without having to report that gift to the IRS. All right, so as that number goes up, the contribution limit will go up. Now there is a limitation on public benefits that after you've put in, $15,000 each year for a while and money hasn't been spent, if that happens, and the ABLE account reaches $100,000, then if the child is receiving SSI, SSI is suspended. But the child can continue to receive Medi-Cal. So if they're, if they receive $1 of SSI and they automatically receive Medi-Cal, they still get to receive Medi-Cal even if the amount in the trust is over $100,000. But most clients that I've seen are making sure that they keep the ABLE account below $100,000 so they can continue to receive SSI. Now the ABLE account was initially set up that Medicaid, so Medi-Cal is California's cutesy version of Medicaid, right? So the ABLE account was set up so that Medicaid would bring a reimbursement claim, just like the first party special needs trust upon the beneficiary's death. But states were allowed to waive that requirement to opt out of it, and California is one of the few states that has opted out. So Medi-Cal will not go after money remaining in an ABLE account after the beneficiary's death. So that's really good news for California residents. Let's go on to the next slide. Okay, so here are a few updates. So what if you set up a 529 account for your child, and then later you realize your child is disabled and probably won't be able to go to college. You can roll over $15,000 a year, right? Because there's still that cap on the ABLE account, $15,000 a year from the 529 plan to the ABLE account. And this is really cool. If you're a disabled person who's earning income because you're employed, you can contribute more than the $15,000. You can contribute an additional $12,760 in 2000, which will probably go up a little bit in 2021, as long as the beneficiary is not participating in their employer's retirement plan. So this is really meant to provide some retirement money for the beneficiary. So really, in this situation, the ABLE account can receive up to almost $28,000 a year, which is really terrific. Okay, next slide. So where do you set up an ABLE account? There's only one place to set it up, and that's online at one website. Okay, so don't go down to Wells Fargo and say, hey, I want an ABLE account. Can you help me set one up? No, instead you go online, you go to www.calable.ca.gov. And this is the screen that you'll see. Well, you'll see part of it, and you see that orange thing on the screen that says open an account. You press on that. You'll need to know the disabled person's social security number, and if the disabled person isn't going to manage their own ABLE account, then you also need the representative's social security number. It works a lot like the representative payee for SSI or SSDI. And then you do set up a regular checking account at the bank of your choice, and then you let the ABLE account people know where the routing information and the account number for that bank account, and then they kind of connect to each other. So the CalABLE runs the back end, which I believe is run by TIAA CREF. And then the bank is really the receptacle where the money is held. And now CalABLE does work with a prepaid Visa debit card. So that makes it a lot easier to spend money than it used to be. So I feel like, California is really doing a good job trying to update their ABLE account. It only became available a couple of years ago in California. We're one of the last ones, but now it's available here. If you have an ABLE account in another state, that's okay, but you can roll it over to a California ABLE account. You just can't have two open at the same time. I think that's all I have on the ABLE account. So let me pause there and see if there's questions.
No, it was another perfect transition right after the other question before you switched. Someone asked about any benefits to establish CalABLE account, which you went into. So unless you have any other 2 cents there on the biggest benefit, I think that covered those questions. Unless anyone has any right now they want to put in the Q&A box or the chat function.
Great. Can you repeat the question one more time?
Yeah, so, and they asked us right as we were going into this section. It was, is there any benefit to establish a CalABLE account? So I think you covered a lot of that.
Yeah, I think it's a great option. It's really terrific. I might actually have, let's go to the next slide. Okay, yes, I do have a comparison chart. So this compares when would you set up an ABLE account and when would you set up a third-party special needs trust. And most times you do both. So they really complement each other. There's, the third-party special needs trust is to receive, it can receive a lot of money. ABLE account, a limited amount. But the ABLE account counts as the beneficiary's own money. Now, this is really important when you're dealing with SSI. As some of you may know, and you may not know this might be gobbledygook, but if you do have a child who receives SSI and their SSI check has been reduced because somebody else is paying for their food and housing, if the ABLE account pays for that disabled person's food and housing, it's as if the child is paying for their own food and housing, so they don't get an SSI deduction, which we call an ISM, in-kind support and maintenance deduction. So using the ABLE account to pay for food and housing is really beneficial. I put in my third-party special needs trust that the trustee of the third-party special needs trust can distribute money to the ABLE account. So it can really go there, and then the ABLE account then pays for the rent, and then SSI is not deducted. Anyone can control the third-party special needs trust except for the beneficiary and spouse. And there's no Medi-Cal reimbursement claim upon the beneficiary's death for either of them. And then do I have one more page on the comparisons? Let's see. Right, how much can you fund? So I put that in there as well. Is it gift tax free? I'm not going to go into that very much, but ABLE account, a gift to an ABLE account, you don't have to report it to the IRS. A gift to the third-party special needs trust, you do have to report it to the IRS. Then we talk about some income tax and types of distributions. Right, what are qualified disability expenses? That's really what anybody needs to live during the day. So it can be transportation, food, medicine, doctor's appointments, kind of anything you need. The third-party special needs trust does not have that limitation. So that can also be used for a fun trip to Disneyland or a around the world trip, or things that make the beneficiary really happy that may not qualify as qualified disability expenses. Okay, any other questions about the ABLE account before I move on?
Those are all the questions right now.
All right, let's keep on going then. Okay, so how does the special needs trust fit into somebody's estate plan? That's what I want to talk about now. So remember I said there's a lot of different types of trusts. One type is a revocable living trust, which hopefully many of you have set up. The main reason why we set up a revocable living trust is to protect the person's assets from the probate court system. Remember, we said we want to avoid the court system at all costs, and especially in California, it's time consuming, it's cumbersome, it's expensive, it's public, it's horrible. So we put everything into a revocable living trust, or most things, and you can always change it. In the trust, you name where the money is going to go, and you name who's going to take over managing it, the successor trustees. And because all of that is spelled out in the trust, we don't need the court's involvement. Okay, so if you have, and the magic number is weird this year. It's $166,250. If you have more than that in your name without a beneficiary listed, then that asset would go through probate. So we need a revocable living trust to avoid the probate court system. Okay, next slide, please. So I want to talk about a pretty recent update in the law that I think will be helpful. And this also shows how an estate plan really flows, what it looks like. Okay, so in this case, we had the Jones family, and they set up a trust. And in their trust, it said upon the first death, the death of one of the spouses, the trust splits into two trusts, the survivor's trust and the bypass trust. And you may have a trust like this. We had to do that before 2013 because at that time, the estate tax exemption was pretty low. It was, for a long time, it was $1 million per person. You could only die and pass along $1 million, up to $1 million. Anything above that was taxed at a very high percentage. And also there was no portability. So to port is to transfer. So at that time, the survivor could not transfer the deceased person's estate tax exemption. So the deceased person, it was like use it or lose it. It had to be captured. That estate tax exemption had to be captured in the bypass trust. Everything else went to the survivor's trust. And then upon the second death, it goes to the kids. All right, so what's so special about 2013? And around that time, it's like between 2011 and 2013, a lot of things happened. But one of the main things is we did get portability. So now the survivor can say, hey, I want all of the estate tax exemption. I want the deceased person's estate tax exemption, and I want my estate tax exemption. So now the survivor can receive all the money, have all the estate tax exemption, and be protected. And also, the estate tax exemption amount went way up, all right? This year, it's $11.58 million per person. Next year, in 3 weeks, it's going to go up to 11.7 million per person. Now in 2026, it's scheduled to decrease to about 6 or 6.5 million per person. That's because this was actually one of the Trump tax cuts, and that was only for 10 years. So in 2026, it sunsets, goes back down to 6.5 million, which is still pretty high for most people. Let's go to the next slide. So this is the simplification that I'm seeing a lot of my clients are doing. They're saying instead of the split, we have everything go to the survivor's trust. And the survivor has all the estate tax exemption. And then upon the second death, it goes either directly to the children, the typical children, or in a lifetime trust or in a trust that distributes at certain ages, and then to the special needs trust. So when I'm doing an estate plan, I draft the family trust and I draft the special needs trust. Those are the two trusts. And then the rest of it is included typically in the family trust language. Okay, next slide. So when families have kids with special needs, a lot of times the main focus is on the child with special needs. But what about the typical children? I have two boys, Caleb, who's 8, and Isaac, who's 6. Caleb has high functioning autism, And especially when we were doing a lot of intervention for him as he was younger, most of the focus went on him, and Isaac was like, he was just along for the ride, you know. But we want to plan for Isaac as well. So, you know, if the child's pretty responsible, the typical child, and they can manage their money, then they can just get the money outright. Or sometimes people say, you know, I like the children to get their money in tranches and in steps. So they get some of it at, let's say, age 25, it can be different, you know, but at age 25, and then if they blow it, then they still have another chance. They get some of it age 35 or 30 and some of it age 35. So it's kind of spread out a little bit. Another option is a lifetime trust, and that is that's become more popular nowadays. So what that says is that the child receives their inheritance in an irrevocable trust, like the special needs trust, but it's not quite as restricted. They can distribute cash, and the big difference is that the beneficiary of the lifetime trust can also act as trustee of the lifetime trust. If the typical child is doing pretty well, they can manage their own lifetime trust. Sometimes this is called a dynasty trust. There's other names for it. But the really nice thing about this is then the typical child is protected if they encounter a divorce or endure a divorce. All the money is segregated just for them. And if there's a creditor's claim, it has a good level of protection as well. The last thing you need to think about is what happens if everybody's gone, if all the kids and grandkids, if all your descendants, you know, if you're on a big family trip and the boat goes down, I call it the Titanic, right? Think about where you want your assets to go. Okay, next slide. Oh, so that's everything that I have. I'm happy to take more questions. And I am accepting new clients, so you know, you can feel free to reach out to us. I think my contact information is on the next slide. We could go to the next slide. There we go. And so I want to open it up if there's any other questions.
Great, thank you, Ellen. Yeah, we can finish up with some Q&A right now. So again, feel free to submit your questions. The one we have right now is, what type of accounts are advisable to have for the special needs trust as a beneficiary?
Well, usually it's like a checking or savings account. So when it's time for the special needs trust to be funded, you get a separate tax ID number, and you take the trust down to the bank and you set up an account. So, you know, usually the trust assets are managed pretty conservatively. It's kind of like with retirement assets. Like when somebody retires, they have a certain life expectancy, and the money needs to last that long because they're not working anymore. They're not putting in more money. It's just, here's the money we have and it needs to last this long. Same thing with the special needs trust. When the special needs trust is funded, that has to last for the child's lifetime. So, you know, it's important to calculate how much do I think needs to go in there. And then that money is usually invested conservatively to make sure that nothing happens to it. You know, in case there is a market crash or something happens, we want to make sure that it's still there for the child's lifetime. So that's typically the approach with management of the assets.
That looks like the only question we have right now. So people, if you want to ask one last minute question, we have an expert here. She has great knowledge and info. But yeah, other than that, I think we're done with our Q&A.
Wonderful. So if you do have a question that comes up, feel free to send an email to info@cookmanlaw.com. I'm an attorney, so I love sharing my opinions. So I'd be happy to, you know, answer other questions and see, you know, how you might need some help. Thank you so much. And I want to thank San Jose State University for inviting me along. I really enjoyed this.
Awesome. Well, we're glad you could join us today. We had one more pop up, so
okay.
We have time to still do that. So it says, does your law firm accept payment related to estate planning from legal coverage provided as employee benefit through MetLife?
Gotcha. No, we don't. Unfortunately, those, you know, MetLife and other Hyatt legal services, they pay a very low amount to the attorneys. And so we just can't provide the services that we want to with that type of reimbursement. So no, we don't accept insurance.
All right. Well, thanks again, Ellen. And those are all the questions that we have for now.
Wonderful. Thank you.
Yeah, and we want to thank everyone for joining us for today's virtual seminar. Our featured speakers in this Plan Giving seminar series are experts in a variety of fields, including estate planning, trust law, wealth advising, real estate, tax, and charitable giving. They've graciously agreed to share their time and knowledge with the SJSU community. Our next virtual seminar will be taking place on January 28th of 2021 and will focus on trends in pre-IPO stock and tax. An invitation will be sent via email soon. If you have any additional questions or wish to get in touch with the presenter, please contact Randy Baylog, SJSU's Director of Planned Giving, or visit us on the website at legacy.sjsu.edu. Thanks again, everyone, and have a great day.